is to be exercised objectively, judiciously, and upon reason, not arbitrarily, capriciously, or on whims. Here, falling ill on the second day of a grueling two-day hearing, the Deputy President sought a 3-working-day adjournment to Tuesday, 22nd October, to enable him to recover and appear for cross-examination. The Senate defeated that proposal to adjourn until Saturday to see if the Deputy President had recovered. And joined by the National Assembly, the Senate insisted on proceeding in the Deputy President's absence. My Lord, you will see at paragraph 83 of our written submission the case of the then Major General Peter Kariuki versus Attorney General. It is number 3. It is paragraph 3, page 250 in our bundle, where the Court of Appeals said the appellant's request for a 3-working-day adjournment, 3 days adjournment, to instruct counsel was denied. He had been held in a communicado without access to a lawyer for over 147 days. He had less than 10 hours in total, and in a prison setting to instruct his lawyer to prepare his defense. Overturning the court-martial decision denying the adjournment, the Court of Appeal explained, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of application for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right, the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. There are very many cases cited, even in the common law. My Lord, again, I had the privilege of arguing this case before the court-martial back in 1983, following the attempted coup, and also through the High Court, through the Court of Appeal. The conviction by the court-martial was quashed on the basis that Major General Kariuki, the commander of the Air Force, had been denied a fair trial. My Lord, in the interest of time, I was going to highlight the speed with which the whole process from the word go all the way through was done, but including the rest of it. But I invite the court to read our written submission. I already mentioned that after hearing the Deputy President on the 8th of March, finishing at about 8 p.m. Anyway, on the date that the National Assembly considered this motion, they voted to impeach close to 9 p.m. The normal working hours are daylight hours. How is it that the National Assembly could not even wait for the following day to transmit their resolution to the Senate? Well, it was transmitted at night. And the following day, the Senate set the date to commence the procedures. Equally, when the Senate, after depriving the Deputy President a fair opportunity to defend himself, impeached on 5 out of the 11 grounds. Equally, they had to transmit the impeachment resolution back to the Senate close to midnight. My Lord, I'm inviting this court to see this breakneck speed. Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. On a Friday, which is not a normal sitting day. Any thinking person will wonder how the Speaker of the National Assembly, a good friend of mine, senior counsel, how was he able to anticipate the likely decision of the Senate in advance? And above all, although the resolution of the Senate was being transmitted back to the National Assembly after midnight, between midnight and the following day, His Excellency the President had time during the night to get clearance for the person he wanted as his Deputy President from the Ethics and Anti-Corruption, from KRA, from the Electoral Commission. These are public institutions. In fact, the Electoral Commission did not even have commissioners to make a decision clearing the choice of the Deputy President. But I mentioned this to demonstrate the unholy rush. I invite this court to see through the smoke screen cotton thrown about by the National Assembly and the Senate to confuse issues. They were merely saying, we have the numbers. There was no attempt to address serious violation of the Constitution. Lord, I hand over to Mary.